So, ladies and gentlemen, it's 10:30, so it's time. I think one or the other will probably still join us, but we just discussed Swedish versus French approach, so we stick to the scheduled time. My name is Jan Ellermann. I'm a senior specialist in Europol's data protection function, and I have the pleasure today to host this Eden panel at CPDP. For those of you who don't know yet, Eden is not just a garden, but Eden is also the abbreviation for Europol Data Protection Experts Network. It's a network which we founded 2015. Okay, sorry. So Eden, the Europol Data Protection Experts Network, is a network which we have established in 2015, so in the meantime more than 10 years from now. And the purpose is basically to bring together just anyone who's interested in topics drawing links between data protection, law enforcement, cybersecurity in the widest possible sense. And for a couple of years now, namely since 2020, we also have the pleasure and the privilege here to organize an Eden panel at CPDP, and we are very grateful for this opportunity to exchange views also with all of you. So the title of today's panel here is Stranger Things Online, Navigating Child Safety in the Digital Age. And why we picked this topic is that beneath the surface of the digital world, there are some new and deeply concerning phenomena. We're talking about loosely structured and highly disturbing online networks, often referred to as 764-COM. And these networks operate across platforms and borders, and they exploit vulnerabilities. From law enforcement perspective, we see they evade detection, they challenge traditional approaches to child protection, and this is why we considered when CPDP approached us and asked, could you contribute something to the topic of child online safety? We were very happy about that, so I turned to my colleague Anke. Anke Paulus works at Europol at AP Dolphin, so that's our analysis project which deals with all forms of non-Islamic terrorism and extremism, including right-wing and left-wing terrorism. Anke is joined by Jessica Gallicer over there, who's a senior policy researcher at Interface, a European think tank specializing in information technology and public policy. And Jessica's research focuses on protection of minors in digital environments. Then here in the middle, this is Jeroen Bouwman, who's a legal officer at the European Data Protection Supervisor, the EDPS, where he supervises and advises on the processing of personal data by EU institutions and bodies, including Europol, obviously. He works within the area of freedom, security, and justice, primarily focusing on data protection compliance in the context of law enforcement and EU interoperability. And then on my very left-hand side, Jaap Henk Koopman is an associate professor at the Digital Security Group of the Radboud University, Nijmegen, and also guest professor in the Pre-Sec Group at Karlstad University. And last but not least, the author of the book Privacy is Hard and 7 Other Myths. We've talked a little bit about the speaking order, and we think what worked well is that Anke will kick off, Jeroen will provide an EDPS perspective, and then Jessica will broaden the focus a little bit from her think tank perspective, and Jaap Henk then complements the academic perspective. We've agreed up front that each of them will have like 10 to 15 minutes to make points they deem most relevant. And then afterwards, we would proceed to a moderated talk, and the purpose is explicitly to involve you as much as possible. So we are in a very, I think the advantage here is we are in a very, or rather intimate setting. It's a small room, so I think let's say the bar is not that high for you guys to also engage. If you have burning questions, I think I can even say you can raise your arm and then also interrupt speakers, but let's say the concept would be, let's hear their perspectives, and afterwards, let's see what we all think about it. And I will try to moderate that to the best of my abilities. With that, I would hand over to Anke.
Thank you very much, Jan. Welcome, everyone. So my name is Anke Paulus. I'm an analyst with the operational department of Europol. So that means that we help investigators of the units from the whole of Europe in their investigations. The AP that I'm working is at AP Dolphin. AP Dolphin, like Jan said, is extreme right, extreme left, and everything in between, so nothing jihadi related. That means that our scope is broadening right now. The online world is going crazy right now, and especially with minors. So we had to extend our mandate on what we can work on, but that's something that Jeroen will touch upon later. Can I ask to start the presentation, please? I just want to give you a warning. As I said, I'm from the operations, so that means that we go into the devices of suspects, victims. We see what these kids are dealing with. So I just want to give you a little bit of an insight in what our investigations look like. So please be aware that I will show you some maybe shocking images. Don't hesitate to turn away if it's too hard for you. I sanitized a little bit, but just to give you an update on this is what these kids are sharing amongst themselves.
It's the play button, I think. This one.
Yes. Yeah. So what you see here is a video of a young guy. He's in mid-school and he just attacks his school teacher with a knife until she lays on the ground. So this is a minor committing this crime. What you can also see from the screen is that on the bottom of the screen there's multiple users online watching this video. So this is a crime being live streamed in a separate group that has been created by one of the attendees, telling the other attendees, be here at 7 o'clock because then this stabbing or whatever crime will be committed will be live streamed. Why do they do this? Because of the cloud, the notoriety, the status that they can gain with committing these crimes in these closed groups. What do the other attendees do? They cheer. They are the cheerleaders of the suspect at that moment. This is how they create their little community. This is how they create the cloud, as I said. So these are the images that your kids see on their computer screen, on their cell phones. So when I was young, my mother told me, please go and play outside, but come back before this time and don't talk to strangers. Don't listen to them, don't go with them. Now we think that our kids are safe because they're in their bedroom and they're just looking on their cell phone, they're just watching videos, they're just playing games. But actually those strangers that my mom taught me to not talk to are actually on the other side of the cell phone. So every user ID that they talk to can be a stranger. So you have stranger 1, stranger 2, stranger 3. So if you keep this in mind, actually your kids are more in danger than we were. So again, a trigger warning. These are the images that we are confronted with on a daily basis. So as I said, we are not Islamic-related terrorism. I used to work in Islamic-related terrorism, and we were used to, it sounds really bad, but we were used to seeing torture, decapitations, and so on. We were never used to seeing this. This comes in the speed of light. So we, for example, have seen a propaganda video of one of our suspects. He created for himself a 3-minute lasting video. And it's flashing images of girls cutting themselves with his name on her thighs. It's flashing images of people committing suicides, of stabbings, of crimes, of setting buildings on fire. And it goes in a flashing way with really nice music. So it's very attractive for young kids to get involved in. Now, what am I talking about? I'm talking about the COM. The COM, abbreviation for the community. This is actually a group online. It's a loose network, so there's no structure, there's no commander, there is no leadership, but it's a group of groups that they all create themselves. And one of the most known groups is 764, like Jan already said. 764 is very oriented towards sextortion, cuttings, swattings, and all those kind of things. You have other groups, they are more into the true crime community, so in real life committing of acts. So they actually push people to go and brick houses, so throwing bricks into houses, setting buildings on fire, setting cars on fire, and even stabbing people or killing people. The purpose of all of this is to break down society. So one of the questions that I get asked very much is, why CT? What is this has to do with counterterrorism? Well, this is a new way of counterterrorism, apologies. What they try to do is to break down society. They try to recreate or brainwash a whole generation for them to be desensitized to violence. That means that these kids are very easy to be also used, for example, for the violence as a service, which we see a lot right now. We see a lot of these kids going to be recruited online to commit other crimes for serious organized crime organizations. So who are these kids involved in the COM? We have victims of 8 years old to 16 years old, and most of the victims, 80% of them, are girls. Our perpetrators are between 12 and 20, and 80% of them are guys, boys. This changes, so they're interchangeable. Some victims will become perpetrators, some perpetrators were victims or will be victimized again. And they stay in the community. So that is one of the challenges that we see right now. Once we identify a victim and a perpetrator, what can we do then? And how can we prevent them from re-entering in the community? Because the reason why these kids enter or are so pulled into this, the community, the COM, is that there is a place to belong. They finally have someone who listens to them. They finally have someone that looks up to them or that cherishes them, that gives them love, because that is actually the way the grooming works in these groups. So you have young kids going on Roblox, which is very normal, and it's a really nice place to be at as a kid. And then you have these perpetrators who pretend to be a kid. They go in these groups as well. They talk to the kids and they try to get a friendship. They try to have trusted relationship. And then they pull them to other platforms like Telegram, Discord, where they can have more private communication. They promise them a lot of things. So I see that you're wearing really nice earrings. Do you want a necklace with this? I'm 12 years old as a victim, so yes, of course I want a necklace from a stranger. I mean, why not? So in order for me to give you this necklace, can you please give me your address? Okay, I give you my address because I, as a 12-year-old, don't see any danger in it. So the address has been shared. The necklace arrives because that's what they do, because then you build a trust. Okay, I really like you, the love bombing. And then it starts. Do you have pets? Yes, I have pets. Do you have siblings? Yes, I have siblings. Okay, and they build a lore book. So that's a case on their victims, a lore book, and this can be sold to other. I'm sorry, I'm looking at you as my fellow perpetrator right now. This can be sold to another perpetrator, and he can then victimize this victim as well. What they also do with these lore books is they sell it so people can be extorted online for money. What they also do is they use this information in this lore book to extort the victim, of course. So from a request becomes a demand. I have so much information on you right now, so if you don't do this, for example, send me nude pictures of yourself, then I will, because I have your address. I will come to your house, I will kill your pet, I will kill your family, I will set your house on fire. That's what they do. 12 years old, I'm still very impressed. I will do whatever you ask me to. And that's where the cycle starts. That's when they start asking to cut themselves and to commit themselves, which is one of the last steps that they request from their victims. What I said before, I'm a 12-year-old girl as a victim, and this is the aesthetics of the group. This is one part of the aesthetics of the group. We also have other aesthetics, which is more gruesome, more blood, more red, harder. But this is what keeps people in there, what draws them. It's the belonging to something very specific. The gamification is also something that we see a lot. So for example, you have the vetting procedure. To enter a new group, you need to do certain things. There is listings, for example, of certain groups that go around. If you want to be a normal member, then you have to commit an arson. If you want to enter as such a member, you have to have so many victims on your name, with your name in their body carved, and so on. So why are these drawn? Well, because I said the place of belonging, it's cute, it's nice. They also use the other victims to convince new victims to go into these groups. So what the group tries to do is to normalize and to desensitize these young people, and as I said before, which makes them very usable for other crimes to be committed online. Now, what are the challenges from a law enforcement perspective, of course, is legislation and jurisdiction. So it's very difficult because all of these cases, a suspect on the internet will look for a victim. They don't care if it's in the same country. So that's already a problem with jurisdiction. Then the internet, the platform where it's hosted is another problem that we have. The mandate of Europol at AP Dolphin, we were not used to dealing with this many minors. So we had to find a solution on how to deal with minors in our databases. And that's where Jeroen came in and Jan. Then the private companies, of course, I've heard some other panels already, this is a big issue. How do you rectify that, for example, Roblox allows children to create little dolls who are naked and who are sitting on top of each other? How is this possible in a child's game? And it's very difficult for us to rectify this, to understand why. Then the prevention. Like I said before, how do we prevent people from going back in? We have seen a 13-year-old girl being victimized in that sense that she had scars all over her body. She will look in the mirror every day and she will see the name of her perpetrator on her forehead because it was carved in there. So it's a big scar. So every day she looks in the mirror, she will see him. Now she's 16 and she's back. And she's back as a perpetrator and she's doing the same thing to other kids right now. So what we're trying to do at Europol is we try to create a network, and it's named Project Compass. Compass because we try to orient everyone in the right direction. We are now with 28 units that are cooperating in this. And what we try to do with this is to bring people together on the operational side so they can openly discuss cases and work together if necessary. But we also use this network to discuss with each other from investigator to investigator. How do you deal with these gore images? How do we have to go about? Are there tips and tricks that we can use? Because we also want to keep ourselves sane. If a 12-year-old can fall for this and get drawn into this, we can also be desensitized for these images, and we have to prevent ourselves from this. And that's where I want to end up. To defeat a network, we have to be a network. So that's what we're trying to create at Europol, and that's the main task at AP Dolphin. Thank you.
Thank you very much, Anke, for this, I think, very intense presentation. We've discussed upfront about the very explicit content, and we were not sure how to tackle that. Ultimately, we took a conscious decision here to do this with the caveat and the warning. And the reason behind it is that in law enforcement, on many occasions, if you have debates, including from a data protection perspective, you will see law enforcement arguing, well, I cannot tell you here for reasons of operational security. And sometimes that is difficult, including in debates with the data protection community, because it lands as if we would try to hide something. So here, that was a little bit the consideration to say, if you make a conscious decision to join a panel where you expect law enforcement practitioners to share their view, I basically also told Anke, I think that is okay. And I was behind that, but I'm also conscious of the fact that this might be criticized. What was interesting, I think, and very important here is why counterterrorism. We had a lot of debate internally on this as well, including with the EDPS, with Jeroen and colleagues. So I'm sure Jeroen will expand on that. A little caveat here, because I know there are also a lot of commission colleagues running around on CPDP. COM does not stand for the commission in this context here. I hope that became very clear. Then also what I found interesting, Anke, because that was not clear to me, is why that happens, this feeling of belonging, this creation. That is something which is difficult. If you just look at it from the outside, you ask yourself, how the heck can that happen? But it's also interesting from a law enforcement perspective, because what you see here is, as law enforcement officials, we kind of, or Anke and colleagues kind of even need to have a psychological degree, you could argue. And at the same time, these colleagues are also at risk to be affected themselves. So this is where I at least owe my huge respect to you and others who do this on a daily basis. Interesting also this technique of luring victims into the hands of offenders. I think the lure book And last but not least, thank you for highlighting the challenges, including jurisdictions, public-private partnerships, but then also victims who become perpetrators. That's, of course, also something. It's so easy to say these bad guys, and how bad is that? But behind every human being, there's a story. And maybe the perpetrator from today is the victim from yesterday. So this is a very complex matter, including from a data protection perspective. And this is why I'm very grateful that Jeroen was available here to join this panel. Jeroen, floor is yours. Thank you.
Thank you. Thank you, Jan and Anke. So my name is Jeroen Bouwman. I am a case handler with the EDPS. What that means is that I am part of the team that does the practical data protection supervision over these types of activities at Europol, and also the supervision over the processing of minors more broadly at Europol. And so that's what I will focus on for the next 10 minutes. I will try to do this in 3 parts. One, I would like to give a little bit of background on the evolution of Europol, the importance of purpose limitation, and the role of APs. So we have AP Dolphin here, but it's only one of several dozen APs at Europol. So the role of APs at Europol. Secondly, I want to talk a little bit about the practical supervision that we do. What are the types of checks that we do? And then thirdly, I also want you to walk away with more of an emphasis on how important it is for coordination between national data protection authorities and the EDPS when we investigate these cases ourselves. So starting with 2017, this is when the EDPS took over supervision for data protection at Europol. And this was shortly after the then new Europol regulation. And this Europol regulation changed a whole number of aspects at Europol. But one of the more core aspects of this regulation was that it changed the approach to data management at Europol. So where the legal framework before the Europol regulation was very much system-based, so you had systems being regulated almost as silos in isolation, which was criticized at the time, this was replaced by an approach that was much more purpose-driven. So the idea was that we would go for an approach that is more technologically neutral. Europol can use whatever database, whatever systems, provided there are data protection safeguards, of course, that it needs to perform its tasks, but that it would do so only for selected purposes. And so when we're talking about this today, operational analysis is what the APs are doing. This is truly the core of what Europol does. This is the collection of evidence. This is making intelligence packages. This is sending that information to member states. This is gathering additional information from the internet. This is real analysis at the heart of Europol. And so what Europol has done as part of purpose limitation for this is it has created this network of APs. So we have AP Dolphin here, but you also have APs dealing with a whole variety of crimes. You have APs dealing with drugs, you have the APs dealing with human trafficking, you have APs dealing with terrorism to various degrees. And each of these APs actually comes with what is called an opening order or an opening decision. So whenever an AP is created at Europol, the purpose of this AP is defined. This is what Anke referred to as the mandate of the AP is defined. And also a very granular matrix is defined for this AP that lists what type of data can be processed within this AP. So we're talking categories, biometrics, for instance, financial data, but also on whom this can be processed. So this is a matrix really that you can see. So for instance, you would have less information on certain categories such as witnesses for clear reasons within certain APs. But of course, this is not something that was just done in 2016, 2017, and then we never looked at this again. I mean, this is almost 10 years ago, which is scary for a lot of us. But these APs also have to evolve, especially when you have events that are such as COVID-19, which really radically change our society in many different ways, not just in crime. You will have to have amendments to the AP portfolio. And this is one of the aspects in which the EDPS is frequently evolved every few months, I would say almost. We have a discussion with Europol about changes to the scope of one AP, merging of different APs together, maybe new data categories that are needed for certain APs. And in this dialogue with Europol, actually, we will either provide further recommendations on what categories we see as not sufficiently justified to be included in this AP, to remain necessary and proportionate for its purpose. But also we can give other advice as well, where we see that there are aspects that we could be more transparent about to the data subject and to the public. And so one of these cases, this was indeed with AP Dolphin, when this mandate was being expanded. And where also, on the one hand, you had the expansion of the mandate of AP Dolphin, but also the expansion of data subject categories. And one of the major concerns that we had with regard to the inclusion of this type of extreme behavior in a historically terrorism AP, is that this is still widely known to the public as a terrorism AP because it's on Europol's website and used to be on Europol's website for a long time as a political terrorism AP. And it's also known as this with its law enforcement partners. And so what we do not want to have is data subjects that go to Europol that request access to their data, get the information back. You are an AP Dolphin, you go on Europol's website and you see, oh, it's right-wing terrorism. And you have no clue why this is because you just killed your cat several years ago. And so this is one of the major concerns that we had for the public, also for data subjects in terms of the anxiety that they might experience with that, but also concerns that we have with law enforcement partners that have been working with AP Dolphin for a while and know this as a terrorism AP and might not know it yet fully as this new expanded AP. So these types of considerations we have every few months with Europol. It's really on a case-by-case basis. So we might one time be talking about drug APs and the necessity of health data and overdose information for this AP. Another case, we might be talking about more transparency to the public. And this is one of the supervisory aspects that we have. And this is at the layer of the teams. So at EDPS, we see three main layers of supervision. We have the supervision over the teams, what they do. We have the supervision over the IT system, the system layer, and then we have the supervision over the data, so the individuals, the cases that are being investigated. When it comes to the IT systems, we have several ways in which we supervise this. This could either be proactive, so inspections that we carry out on certain IT systems that have come to our attention, or this can be reactive. So there is a whole process at Europol through what is called data protection impact assessment. I'm sure most of you are familiar with this. This is an exercise to estimate the degree of risk to data subject for certain processing information, processing activities. Of course, Europol has a lot of these high-risk activities, and so a lot of DPAs are being conducted by Europol, and sometimes these result in a prior consultation with the EDPS for the most sensitive. For instance, one that we had not too long ago that involved minors to some degree was facial recognition. So the central facial recognition engine at Europol was prior consulted with the EDPS. And there we went through the performance of the system also across different demographics. And we relied a lot on good work being done by NIST, the National Institute for Standards and Technologies, which do really great work in looking at the different demographic effects and demographic accuracies of these different tools. And what we found, for instance, is that this specific engine that was being proposed as the central facial recognition engine had not been fully, to our degree, we did not find it sufficiently tested on under 12-year-olds in terms of its performance. And so one of the feedback that we gave to Europol was that for the initial operational deployment, we do not think this should be done with this degree on under 12-year-olds, and this was actually accepted by Europol. So this was not deployed for under 12-year-olds. There are different facial recognition engines at Europol, but for this central one. So this is just, again, one aspect of one layer of supervision that we do for minors. Then thirdly, we have the layer of data. So this is where we really look individually at cases, and that's where we do an investigation of whether the data that is processed at Europol on minors is what is called strictly necessary and strictly proportionate. So this is a very specific, very high bar that has been introduced in the Europol regulation for the processing of minors and certain other categories of sensitive individuals. And so what we do in those cases is, again, we work both reactively and proactively. Reactively is we get complaints at EDPS, usually about individuals that have accessed their data at Europol or have requested access to their data at Europol and are perhaps not content with the answer they have been provided. They can come to the EDPS and lodge a complaint. In those cases, we will always investigate this, including going to Europol, and we will look through the systems ourselves, including all of the logging of those systems. So this is not just something that we then ask Europol, what is up with this? We actually go on site to do those checks. We also do proactive investigations, and there we carried out an inspection of Europol about all of its minors that it has received from international organizations and from third countries on minors that are under 15 and marked as suspects or so-called potential future criminals. So there again, we carried out a sampling-based approach to see which one of these minors were strictly justified, and we asked for corrections where needed. And since a few years, because of this sensitivity that we also have with regard to minors processing at Europol, what we actually do together with the member states is once per year we get an extract from Europol's databases, For all minors, currently our scope is, again, under 15 suspects and potential future criminal. That's the area we're focusing on for now. But we get that every year, the metadata on this population of minors, and we will submit those packages to the respective member states. So that, because we can look from our side at Europol how information is processed, but when information is provided by member state police forces, by the French police, this is under the responsibility of France and also of the French National Data Protection Authority. And also from our side, what is important is often we see quite a bit of information at Europol, because Europol has a good view of the case, but it does not always have the full case. We do not always know how was this information collected back in the day. So in order to know whether something on a minor has truly been processed lawfully all the way through the chain, we also have to involve these other actors. Because we cannot just look at it from our perspective, see at Europol everything looks good, and then that's the end of it. So we provide this information also to the member states, and we do coordinated actions with them on this. And just last month, actually, we issued for the first time a joint report. So a report on our coordinated activities with 10 member states, with some of our common findings that we have in this specific field. So the sending of minors as suspect and potential future criminals to Europol. I think it's quite an interesting read for you also after this event. I think for now I will restrict myself to this in terms of information, but happy to answer any further questions.
Thank you, Jeroen, for your elaborations on how EDPS works versus Europol, and the particular focus on analysis projects, which is, as you explained, very important in terms of purpose limitation. Before that, indeed, we had a more, let's say, system-focused legal framework. Like Jeroen explained, when it comes to the scoping of analysis projects at Europol, we work very, very closely with the EDPS. But it's not only in this area, and honestly, I would also like to seize the opportunity to thank not only you, Jeroen, but also EDPS colleagues overall for the close collaboration we have, because that is something which is maybe not always self-evident in public perception, but something which we need to rely on, because you need people like Jeroen, whom I can literally call on a daily basis, also with smaller issues, to say, look, that's our opinion here, that's our take on it, can we informally consult you on this? And then we take it from there, and as necessary, it will be formalized here. Also interesting, I think, your elaborations on data subject access requests, because I'm sure this is a concern also here from the audience to say, okay, we look at this, there are kids out there who do stranger things online. This is the title. But if you then ask for your data, whether or not you are processed at Europol, you might find out you're being labeled as a terrorist. Well, there are question marks, of course, and I'm sure we're going to dive even deeper into that. Just, Jeroen, if you say, just because you killed a cat, I can tell you from own experience that animal lovers out there who will not consider that a petty crime, yeah? Just to be clear on that. No, but also one point I still wanted to emphasize is you rightfully said there's emphasis on data protection impact assessments, also on prior consultation with the EDPS, at least for the most risky processing operations. So here I can kind of proudly say, as Europol, to the best of my knowledge, we are kind of leading amongst EU agencies, because we have 33 completed prior consultation proceedings with the EDPS, another 40 plus in the pipeline. But of course, those are the most risky ones. Huh? And what I also found interesting and very informative here for the audience is we don't just deal with the EDPS, because Europol is a complex environment. This can only work if on EDPS side, they closely collaborate with national data protection authorities. And by the way, from the side of the data protection officer of Europol, the data protection function, which I'm a member of, we are trying to do the same. We are trying to closely collaborate with our counterparts in national police forces in order, let's say, to find alignment here. So in practical terms, that means if we receive, as Europol, guidance from the EDPS on the processing of personal data relating to minors, we will convey what we learned, let's say, to our counterparts at national police. And that is, I think, how it should be, to my opinion. With that, I would like to hand over to Jessica. Jessica, floor is yours.
Thank you very much, Jan. And as Jan mentioned in the introduction, I'm a senior policy researcher at Interface. So we are a tech policy think tank that's based in Berlin, Brussels, and Paris. And together with my colleague Lena Maria Borsveld, we are leading a research program that's called Strengthening the Digital Public Sphere and Platform Regulation. So we are very focused on platform regulation and especially Digital Services Act enforcement, with a specific focus on the protection of minors. So I have been also following the whole debates on social media bans and age verification in France and at the EU level. So if you want to have a chat about this later, I'm happy to do so. But to come back to our topic today, so we've heard about what can be done once some illegal activity is observed on a law enforcement side. And I would like to broaden a bit the policy perspective here and see what could be done to prevent those harms and the grooming from happening in the first place. And I'm not opposing both things here. I just want to make it clear that it's very complementary and even very intertwined. And so we need both law enforcement and prevention and platform regulation. So as was mentioned before, these groups and this network is not operating on the dark web. They are grooming young people on mainstream platforms like Discord. And I would like to spend a bit of time on Discord here. Given my focus and my expertise, the question that I'm interested in is Discord covered by the DSA? So the answer is yes, but because Discord is an online platform given some of its features, but it's not one of the very large online platforms that have additional obligations under the DSA. So it's not a VLOP. But as an online platform, it does have some obligations under the DSA. And I would just like to quote 3 of those, which I think are the most relevant for our discussion here today. So one of these obligations is to have notice and action mechanisms. So they must provide a way for users and also for authorities to report illegal content easily. So that's, for instance, through accessible reporting tools. The second obligation that they have is to have measures against misuse. So typically they need to suspend users who post manifestly illegal content. And the third one is protection of minors. Under Article 28 of the DSA, they must put in place appropriate and proportionate measures to ensure a high level of privacy, safety, and security for minors on their service. Now, does Discord comply with these obligations under the DSA? My intuition from what we have heard so far and what we all observe on a daily basis is that they apparently don't fully comply, but that would be for a regulator to decide. And just to give you a concrete example, the creator of the 764 server on Discord, which in fact was a minor, he was a 15-year-old teen from Texas, he was banned multiple times by Discord. And I think at the peak of his activity, if one may call it so, he was banned on a daily basis on Discord, and all he had to do to be back on the platform is use a VPN, create a different email address, and he was back on the platform. So he was continuing to post things like, child pornography and continuing to do all the horrible things that we have seen. And the bans basically didn't help with anything. So I would greatly encourage the relevant regulator, who to my knowledge is probably the Dutch Authority for Consumers and Markets, as the digital services coordinator where Discord has established an entity in the EU, to look into this. Because at the very least, the current situation raises serious questions about DSA compliance when it comes to Discord. Now, if I zoom out from Discord, grooming also happens on social media platforms like TikTok and Instagram. And these are 2 flops under the DSA, and they do have additional obligations. The most relevant here is probably the fact that they must conduct systemic risk assessments under Article 34 of the DSA. And if necessary, they need to put in place mitigation measures with regards to these risks under Article 35. This means identifying and analyzing the systemic risks stemming from the design or the functioning of their services, which includes risks related to various things like illegal content and fundamental rights, but also the protection of minors. And for now, the risk assessments that have been published by these platforms are not really satisfactory, to say the least. I know there's a lot of people maybe here working on risk assessments, and they could tell you a lot more about this. So I know we are asking a lot of the European Commission, but it's also something the European Commission should be doubling down on, I think. So all this to say that the DSA is already a very powerful tool that, if used properly and to the, its full capacity, could already allow regulators to force online platforms into addressing harms like those caused by the COM. And I want to address the elephant in the room. I don't think we need to be debating for 2 years about age limits to start and tackle the issue at the core already. And I think that's where safety by design also becomes important, because we often frame these harms as isolated criminal misuse of the platforms. But in fact, the scale and the persistence of these networks also raise questions about the platform architecture itself. Some of these questions are, how easy is it for adults to contact minors that they don't know? How easy is it to recreate accounts after being banned on these platforms? And I know on some gaming websites, there is some best practices here about how to ban definitely someone. So that could be one inspiration. Another question is, how easy is it to migrate entire communities across platforms as well? I'm sure that's something that Europol is faced with. And also how much friction exists before a child is exposed to harmful content or contact. Because we are at CPDP, I want to stress that safety by design doesn't mean mass surveillance of private communications. It is designing services in a way that reduces foreseeable risks to children from the outset. Because there are no longer unforeseeable or isolated risks. The patterns are now well documented. So if someone can be banned every day and recreate an account within seconds, hundreds of times, this is not a moderation issue. It's a product design issue. And so to conclude, I would like to bring the perspective of minors, because I think it's important that we do not discuss children only as passive users or as victims that shouldn't be online at all. Because for them, these spaces, as was mentioned before as well, is a way of creating a sense of community, of creating friendships, of being creative and finding support as well sometimes. So the policy objective here shouldn't be to educate them out of online services or online spaces, but making these environments safer by default and also by design, because it's not the same thing. And in the end, children shouldn't bear the burden of navigating sophisticated systems designed to maximize engagement and time spent online, while at the same time having to identify grooming tactics, manipulation, or coercion as well, all on their own. So I'll stop here to be mindful of time, but I'm happy to take questions as well. Thank you.
No, super. Thank you very much, Jessica. And I think it's really interesting and also informative for the audience, I hope, because we are making a move here from, let's say, a truly Europol operational perspective, then the data protection supervision of those activities. And what Jessica is bringing now is the message, well, this issue cannot be tackled by law enforcement alone. And I think that's a very valid point. It also, what I take away here is, if you thought that this is taking place in the darkest corners of the internet, darknet, and so on and so forth, you're mistaken. It's taking place right in front of our eyes, right with the tools which your kids are also using. So, and that is the worrying part, I believe. And from an EU perspective, I think you highlighted rightfully, it's not like nothing would have been done. So indeed, the Digital Services Act is on that. Even for the smaller platforms, there are at least certain obligations, like reporting mechanisms have to be there or protection of minors has to be assured. But nevertheless, you have the stories where 764 server is mounted, is installed on a main platform like Discord, and then there's a ban, but this ban is being undermined on a daily basis. And that is, of course, where you ask yourself, how can that be? And I appreciate very much your point to say, well, that is a design issue. And if we talk design, indeed, I would concur. Safety by design, not mass surveillance, also a nice punchline, which I would certainly subscribe to. But with that, over to Pink.
Thank you. Maybe because of the word design there, I guess. Thanks Jan, for inviting me to this panel and to the previous panelists for their statements. Let me first respond to what Jessica was saying. I think indeed what is important here is to look at the design of the platforms and the systems that we're talking about. And indeed, the whole idea of thinking of something like safety by design is an interesting way of approaching this. But not that I want to go into my intervention at this moment, but I think this is something that we should maybe debate at a later stage. And that's the question like, okay, what does safety exactly mean here? Because it sounds warm and cozy and nice. But it could have all kinds of like side effects, and from my experience as a parent, my kids have now grown up. There's a limit to the amount of safety I would have liked to offer my kids, and I'm actually happy to have at some point also some level of unsafety. So this is something to discuss. Okay, what does this mean? And in particular, this brings me to the topic of my intervention, and this is about one of the things that has been hotly debated in Europe right now is age verification, age gating. You already alluded to this, and you already mentioned the issue that like a very simplistic age gate whereby we say that every social network should be age gated negates the fact that social networks also have very strong benefits for minors. They do give a sense of belonging, especially if you're not very mainstream. It may be very hard to find peers that have similar interests, and so that for that it's very good to have these social networks, and therefore it's very risky to be using age verification in an unlimited, unfettered sense. And the problem here is that the discussion about this age gating is a complex issue because many different kind of like topics come together here. These more social topics, but also more the technical topics. So, for instance, if we talk about age gating, there's actually two different methods of doing this. One of them is age estimation, and the other is age verification. Now, age estimation uses all kinds of like tools to guess the age of the person that's trying to sign in. This could be based on behavioral profiles. This could be based on biometrics. This could be based on, okay, you have to show a live image of yourself. And clearly these kind of like methods of doing age gating are very invasive. And this is one of the reasons why in the context of age verification and in the context of age gating, privacy issues have been brought up extensively, for instance, by the Electronic Frontier Foundation. However, if you look at the other way of doing age gating, namely age verification, there are actually very privacy-friendly ways of doing age verification. Yeah, I mean, based on technologies invented 10 to 20 years ago in the context of anonymous credentials, the idea being that you can get a proof of age issued to you, a little bit like you get issued a driver's license or a passport, and that you can actually use this document in a completely privacy-preserving way to only prove that you have a certain age. And actually you can do that in such a way that this disclosure of your age is done in a completely unlinkable fashion. So actually, if we only look at the privacy aspect, there are solutions that are truly privacy preserving. So that in and by itself is not a risk. However, there's always a big however. The problem is that in all the proposals that are currently being developed, and for instance also the application for age verification that the European Commission is proposing, this privacy protecting feature is not mandatory. So that means that actually the proposal for age verification that the European Commission is now proposing does, at least in theory, allow a kind of like tracking of the use of these age credentials. So this is really sad and unfortunate, and actually something that should not have happened if the Commission would have been slightly more strict. And this does not only apply to the age verification app that is being proposed as a stopgap measure because we do not have the European Identity Wallet yet. It also applies to the European Identity Wallet. The same risk is there. It is not required that this European Identity Wallet uses so-called zero-knowledge proofs to actually preserve the privacy and make the showing, the presenting of your credentials truly privacy-friendly. And of course, in the European Identity Wallet context, this is even more important because this is not only about proving your age, this is about proving all kinds of like attributes about yourself. Now, one warning here, that even if, and this is something that worries me in the back of my mind when we're talking about all these kind of like technical measures to do things, even if the European age verification app or the European Identity Wallet was truly privacy preserving, that does not necessarily mean that people using this app will believe that it is privacy friendly. So how to get this message across and how to make sure that people actually trust these kind of services is very important. And the problem, of course, is that because of the way these things are being decided and because of the way that the current designs are actually not really privacy friendly, doesn't give the European Commission a really good starting position to then say, once they do actually design this in this way, to say that they are actually truly privacy friendly. Now, with age verification, let's suppose we have this system where you do it in a totally privacy-friendly way. So privacy is not an issue. We still do have other issues. One of the big issues is this concept of level of assurance. How do you make sure that the age being proved is actually correct and actually belongs to the person that is using this service? This means that you have to have a kind of like connection between the user and the thing that he or she uses to prove their age. And the way this is now being proposed is, well, we use an app on a smartphone. And to make sure that that this app cannot be easily copied, or the credentials that are stored in this app cannot be easily copied. It has to be a very modern smartphone. And if we look at the proposals for the European Identity Wallet, countries like the Netherlands and Germany have required Google Play integrity as a requirement to ensure the strongest possible binding of this app to this particular smartphone. But then we have a problem, because that means that this app for age verification and later this app for the European Identity Wallet is only running on Apple iOS or Android devices with the official Android operating system. So all the alternative platforms like iOS and Graphene cannot run these apps. So in the context of the digital autonomy debate, this is really problematic, right? I mean, we're gonna create a European Identity Wallet and a European identity ecosystem running on big tech. So this is something that really should be avoided. And again, where the European Commission could have taken a stronger stance and said, like, okay, we allow member states to develop their own apps for the wallet, but it should be required that these apps also run on alternative smartphones. something else to realize, and again, I think this is something that not many people fully have come to terms with, is the fact that if we do age verification is not only required for minors. Everybody has to prove their age. And then the question is, when and where and how often? If it would be convenient if you would only have to prove your age if you create an account, because then you only have to do it once. The alternative would be you have to prove it every time you access a service. The problem is, of course, that the latter option is way more secure and way more stronger binding the use of this age to the person actually using the service. Because like if it's only at account creation, I could ask my brother or sister to create the account for me, and then I can use it afterwards. So this is a problem. So we see that actually in the deployment of an infrastructure like that, all kinds of risks and usability issues appear that I think are being not really considered thoroughly enough while we're running to implementing these kind of like age verification and age gating systems because of the gruesome things that you talked about in the beginning. And I want to close with that, and I'm happy to take questions.
Thanks a lot, Jaap. Henk, in particular, I was struck by your opening statement when you said, well, I would also like to have some unsafety for my kids. And that's an interesting one, which also as law enforcement, of course, we hear more frequently in extreme scenarios, but I subscribe in the sense that a world without freedoms would probably also not be the kind of world which we would like to expose our kids to, certainly not. You expanded on social media bans and age verification, which I think is a super interesting topic because talking from own experience, I also have 2 kids now, teenagers. When I first learned about the example of Australia, let's say introducing social media ban for children, I was all in. Emotionally, I was all in because as a parent, I also have so many situations where I think, what the heck? I mean, why are they in front of the screens again? And I look at myself and I'm not much better. And you feel like this is such a good solution if up until the age of whatever, 16, you don't even touch that. On the other hand, it's not only privacy issues like you said, but there are also issues like if you introduce that for a number of platforms, for instance, what will happen is your kids will depart to other platforms. They will go underground. Whether or not that is better, you can have doubts. Thank you very much also for expanding on the possibility of privacy-preserving tech solutions. That's interesting. You highlighted that the Commission proposal is not mandatory. That's a weakness. But what I found even more interesting is that it would run via an app on smartphones which have to be Apple or Android phones, if I understood correctly. So that indeed is an issue with digital sovereignty. As you know, Europol is based in The Hague, as is the International Criminal Court. And many of you may have come across that story, that this court, certain judges or prosecutors who have issued or applied for arrest warrants against Netanyahu, which the US administration did not really support, that resulted in those judges to be disconnected literally from everything. So their email didn't work anymore, their Netflix didn't work anymore, their credit cards didn't work anymore. So just to make a little bit of advertisement here for the Eden conferences, our next one is going to take place 22nd, 23rd of September in Lisbon. So if you are part of the Eden community, which I consider all of you in this room now, so if you want to formally apply, drop us an email at eden@europol.europa.eu. Then it's you also get a discount, and we have why I mentioned that right now is that we are putting together the program, and I want to invite folks from the ICC to tell us firsthand basically what that entailed. And to my best knowledge, the International Criminal Court currently is in serious consideration proceedings even to ensure digital sovereignty on their side. They are trying to get off the hook of all these applications which could be switched off like this. Now it's for a judge or a prosecutor. Tomorrow it may be the whole ICC, because that is not welcome. And that is a real issue, I believe, way beyond law enforcement, of course. But with that, I think we are doing well on time. So we've reached the moment where all of you should actively engage here. So are there already any burning questions? I see first a number of hands here already. Do we have a second micro? There's a microphone also. So if you would, we start here. Oh, we start from the back. That's easier. You're in the back. We start from the back.
Hi, thank you so much for the various presentations. I work with the Mary Collins Foundation in the UK. We're a survivor-focused charity for those who've experienced child sexual abuse mediated through technology. We have started to see comm groups come through our referral lines, but I think it's interesting that kind of public knowledge around comm groups hasn't fully penetrated yet. So within maybe child safety or the tech or law enforcement, it's obviously there, we know about it, but it hasn't sort of trickled down yet. I'm curious why that might be. Maybe not wanting to drive interest and curiosity, obviously. But in terms of these cases, it's obviously nuanced because some of the perpetrators are adults, some are children. But Anke, specifically to you, have you any examples of publicly known successful convictions for these types of crimes? And what are the kind of corresponding sentences for those?
Well, thank you for the question, first of all. There is the White Tiger case in Germany, for example, that is now on trial, I think. There was a big problem with what is CT and what is serious organized crime, so they were still debating on what we're going to put into prosecution or not. But I think they have decided now, so he has about 170 crimes on his name at this moment, so they will push forward. In Belgium, we have a case of one suspect who was 17 when he was arrested, so he was still a minor, but he will now be prosecuted as an adult, so he will be taken out of the minor status. So those are two cases already that are publicly known. Of course, we work together with the investigators, so we see a big change in how these cases are being treated. So we hope by spreading the word, also this platform is very good for us because this is another functionality that we can tap into. So that's what we're trying to do, share awareness as much as possible. So at least these children, because we're still talking about children, they get the right support, even though if they have committed these very horrific crimes, I think they also need to be re-socialized and maybe rehabilitate back into society as they're juveniles, so they will become what we will rely on in the future. So they also need to be brought back into society with a better look on what they did. So regarding that, prosecution is difficult because at this moment, a lot of them are being slapped on the wrist, don't do it again, don't go on the internet, and that's it. But they have just committed 8 murders or enticed to 8 suicides. So they come back online with a lot of clout, is what they call it, famous status, whatever. And they have an extra badge on their chest. So that's something that we're debating big time. The big issue with public awareness is that we don't want to feed into the narcissistic brains that these perpetrators have most often. So if we talk about cases related to the COM, we will never say the COM 764 or any affiliated groups. We will never talk about the names of the perpetrators or the usernames that they have used. Because, for example, we have seen one of the perpetrators taken out of the community. He was locked up in a psychiatric ward because there was other stuff going on as well. And his friend used his moniker, his online username, to go on in his name. So that is also a difficulty that we have right now. How can you connect the online world with the offline world? In that sense, I have a username, but Jeroen can use it for me. And we have no idea on the other side of the investigation if it was me asking for that girl to commit suicide, or if it was Jeroen at that time using the moniker to ask for the victim to commit suicide. So that's also something that we're trying to work on. Yeah. Thank you.
Super, thanks a lot. There were additional questions in the room.
Yes, good morning. My name is Jolien Heijslink. I'm a DPO of the National Institute of Criminalistics and Criminology in Belgium. First of all, thank you very much for this very interesting but also very confronting panel. And thank you, Eden and Jan, for another excellent moderation. When you organize a panel, it never disappoints, so thank you very much. My question is for Mr. Wouwman, for Jeroen. You mentioned when monitoring, so it's a practical question, I'm a DPO, so. You mentioned that you are doing a lot of DPAs when monitoring IT systems, DPIA, sorry. And I was just wondering, of course, a DPIA needs to be done before the processing activity, but you can, if the processing activities change, you can adapt to DPIA. And I think that maybe in law enforcement, not sure, that's the first question, that happens a lot, that you do your investigation and then you see, oh, wait, we detect other data, we see more risks. So first, does that happen a lot? And secondly, yeah, in the process of doing your DPAs, how do you perform that? How do you execute that in the process of doing your DPAs? Thank you.
So I'll just do with a little bit of clarification because, of course, we as EDPS review the prior consultations that we have received from Europol and their DPIAs. So we evaluate their DPIAs. But those DPIAs are, of course, prepared by Europol, by the controller, with a lot of assistance from the data protection function. And they have a colleague there that is truly very specialized in this. And she ensures a lot of consistency on that end. And I think that's also what you need in terms of, well, as you will know as a DPO, you need to have that level of expertise, that level of consistency. And I think what's important to note there as well is that even before the EDPS took over supervision, there was already the DPO function at Europol, and this has existed for a very long time. So there's a lot of expertise there that can feed into these kind of consistent assessments, and they can help the controller. But what we see, at least from Europol, is that it is very much controller-driven, but very much assisted by the DPO function. You asked about substantial changes to the processing, requiring a change to DPIA. That is something that happens at Europol. And we have received prior consultations on the same subject matter when it has been a very important change to the processing that was underlying it. We have seen this in some examples, such as Quest, which is known. It's a tool to query Europol that had a new generation. We also have seen this in the area of child sexual abuse material, actually. So new generations of tools to process child sexual abuse material with very innovative new technologies that can be integrated. And what we have seen there is that it was an iterative approach. So you had the existing data protection impact assessment for that tool from back in the day that was then complemented with additional plugins, let's say the additional technologies that add a layer on top of that. So there's something that we see as EDPS as well, that Europol does. Is this answer to your question?
And so that's also in the process then to review that there's like a signal function. Okay, we've come across new risks, so we need to amend or redo
Clearly,
the DPIA.
yes, because they end up on our desk, and we have also reviewed their DPIA processes, even for things. So it's not that we just receive prior consultations and we never look at other stuff, right? We have gone on site also to inspect the DPIAs that have not made it to us to double check whether this was truly of the risk level where it should not be prior consulted. It's kind of a trust but verify exercise that we do. But the true experts actually in coordinating this within the organization is Europol's DPO function, because they have this task within the organization.
Okay, thank you.
Yeah, and just to complement that very briefly, in the end, there's no black and white in these matters. You will always have situations where you're not sure, okay, do we have to or should we prior consult or not? But there's also a possibility then to informally check. This is where I said earlier, sometimes it's a phone call, a message to say, look, that's the situation. Do you think we should or not? Difficult.
It's really interesting. If I just may add something, it's really interesting because in my experience in Belgium, not a lot of prior consultations are being done at the Belgian DPA. So it's interesting to see that, yeah, you work so closely together, and I hope maybe some of the people of the DPA are here today, that it can be inspiring for other DPAs and controllers. Thank you.
Thank you very much. Very interesting panel. So I have a lot of questions, but I'm trying to stay to one. Robert Hoving, I'm from Off Limits. We're a trusted flagger on the DSA. I'm also from InHope, the network of global hotlines. So I work a lot with your colleagues from AP Twins, for instance. My question is to you, Ms. Gallasser. I think, yes, regulators are the answer. Because companies, they're not going to do it themselves. They have different interests. We notice that more and more. I think one part of the solution is also parents, or the people who are around kids. Ubuntu, it takes a village to raise kids instead of from the background seeing the terrible things. Don't you think that now with the COM groups, because what we saw here is of course very gruesome, but me, myself and my team, we have content like this that we flag and that we take down as well. So this is nothing yet. You are aware, I am aware. Now people here in the room are more and more aware. Well, a lot of parents are just not aware. And they don't want to look at it. Don't you think that from a DSA perspective, this actually is a crisis? And I think that under the DSA, you have an article, I think it's 36, that if there is a crisis, you are allowed by the Commission to use the platforms to communicate about this crisis, because this is huge. It's connected to the manosphere, it's connected to so many things, but it's huge. Do you think that from that standpoint that we should see this as a crisis and see that the Commission actually starts communicating about this, that it is a crisis, so that the parents who are glued behind the screens, like you said, which I do myself too sometimes, that they actually see how terrible it is?
So I fully agree with you, and perhaps to come back also on the fact about the question about why is it not more known to the public? We also have to be aware that this phenomenon is quite new. It really, well, it started a long time ago, but it really exploded during COVID. And even myself as an expert, I became aware of it in the summer of last year. So it's really progressive, and now we are talking more and more about it, and that's why also I was really happy that this panel was happening. But definitely we need to be speaking to parents about this, and about the Commission doing some crisis communication on this. I fully agree, but then I think there is also a danger that we would expect a response then from the Commission if we say, there is this thing happening, we need to do something about it. And it's such an emotional and political subject, and we see it with the whole age-gating debate, that my fear, at least, is that the expected answer would be we need to shut down platforms, or we need to age-gate everything. Because I've been in meetings with Commission representatives, or even the panel of experts that's advising Ursula von der Leyen at the moment on child protection and social media bans. One of their questions, because I told them basically social media bans are not the answer, one of the questions they asked, and I find it really revealing, is, yes, I agree with you, but how do we communicate this to parents who have lost children or who need an immediate response? And so my answer is, what's the urge? Are we really 6 months? Is there really an emergency to find an immediate response in the following months? I don't think so. This is an issue where we need to take the time to get things right, and with all the difficulties that were mentioned earlier. So yeah, we should be speaking more about this, but then we have to be careful about how we phrase things, because we don't want to trigger a very emotional response and an outcry, and the emotional panic that is already very ambient. So yeah, that would be my answer.
I'm afraid we also have to take this as a concluding remark, more or less. I would like to thank all of you wholeheartedly for your contributions, but also the audience, and I've seen that there have been additional hands raised. So rest assured, all of us here are still hanging out for a while, so we welcome any kind of interaction and questions you still have. Thank you for being here.